Good morning. Please welcome everyone to this meeting of the Licensing Subcommittee taking place from the Walton Suite, Winchester Guildhall. The time is 10 a.m. My name is Councillor Brian, I'm one of the members of this particular Licensing Subcommittee. The opening parts of this meeting are being live streamed and will be recorded to the YouTube channel. Subtitles are available and advice on how to turn this on is set out on our website. Can everybody please ensure your mobile phones are on silent? In the unlikely event it is necessary to evacuate the building, the fire alarm will sound. Please follow all the instructions given to you by our team. Now moving on to the agenda, can I confirm the chairperson for the meeting?
Yep.
Yeah. Disclosures of interest. Do members or officers have any interests they wish to declare? The application of the new premises licence, the Rising Sun, 14 Bridge Street, Winchester, SO22 OHL. And now into the proceedings for this meeting. The hearings regulations require that the hearing should take the form of a discussion led by the subcommittee, and that cross-examination will not normally be allowed.
Chairman, excuse me, I don't think the public can hear you very well. It might be worth bringing your microphone closer to you.
Oh, sorry. I'm usually accused of being too noisy. Is that better? Okay. Right. The hearing regulations require that the hearing should take the form of a discussion led by the subcommittee, and cross-examination will not normally be allowed. We'll be following the adopted procedure for these hearings, which is set out on the reverse of the agenda paper. Each party will be allowed equal maximum time to exercise their rights at the hearing. I will exercise my discretion to allow additional time if necessary, taking into account the requirement to allow all parties equal maximum time. Only the points contained within the written representations, the report and the supplementary documents can be raised. No new evidence can be considered except with the agreement of all parties. The subcommittee has read all the written comments on the application, which are included in the report. I understand that the following persons wish to address the meeting. I have on my list Richard Taylor, the applicant. I've got other persons, Jeremy Culverhouse, Colin Webster, and Greg. I'm going to get this pronunciation wrong, so I apologise in advance. Connector and Marion Donnell. We can only consider issues relating to the 4 licensing objectives: prevention of crime and disorder, public safety, prevention of public nuisance, protection of children. The subcommittee will also have regard to the national guidance and the council's licensing policy. The licensing officer will now introduce the report, please.
Thank you, Chairman. This application relates to an application for the grant of a new premises licence under Section 17 of the Licensing Act 2003 for the Rising Sun, 14 Bridge Street, Winchester. The premises is a public house which has previously been licensed under authorisation of a premises licence. The premises licence holder became insolvent, and as a result, the licence lapsed. The Licensing Act 2003 allows a person with an interest in the premises to apply for a transfer of the premises licence within 28 days of the licence lapsing. On this occasion, a transfer application was not received, and a new application for a grant of a new premises licence is required. This application seeks to provide live and recorded music, indoors only, and the supply of alcohol for consumption on and off the premises, Monday to Thursday, 1100 until midnight, Friday and Saturday, 1100 until 0100 the next day, Sunday, 1100 to 23:30, and Christmas Eve, 1100 until 0100 the next day, New Year's Eve, 1100 until 1100 on the 1st of January. We received 8 valid representations, which were against the application by other persons, and these can be found at Appendix 2 on pages 43 to 54 of the report. During the consultation period, conditions were agreed between the applicant and Hampshire Constabulary and between the applicant and Environmental Protection, should a licence be granted. These conditions are set out in section 5 of the report. This premises is situated within the alcohol control area, which is covered by a public space protection order. Whilst this doesn't apply to the licensed premises, it does apply to areas in close proximity and allows officers to tackle street drinking and antisocial behaviour. Sorry, that's authorised officers rather than just general officers. That's authorised under the order. So police, for example. Should the subcommittee be minded to grant the application, members may also wish to add additional conditions which are appropriate to promote the licensing objectives, but they should discuss this during the hearing so that the applicant has an opportunity to respond and explain how this may affect their business operation. If a licence is granted, the premises licence cannot be used until a nominated personal licence holder is formally named as the designated premises supervisor, also known as the DPS. The applicant's solicitor is here today and may be able to explain the process from the pump company's perspective and approximate timescales today. And members are reminded that the updated statement of licensing policy was adopted in January 2024. Thank you, Chair.
Thank you. I've just been handed a note that we've been advised that there will be a test of the fire alarm at 10:15, so no action to be taken. So, hoping it's going to keep quiet. Yeah, good. Would you like to address us?
Chair, thank you very much indeed. I'll try and do this before the fire alarm goes off. An application for a new licence made with some considerable embarrassment, really, because, as Carol has said, the application is only necessary because the previous licence lapsed and the application for transfer was not submitted in time. And the embarrassment lies in my office, not with the pub company, with my office. The instructions to do it were sent and they weren't acted on quickly enough. So the backdrop to this application is, had we filled the form in and paid £23 fee, this application wouldn't be necessary, the licence would remain in force and we wouldn't be here at all. But it is, and so the new licence application was necessary. The new licence seeks to replicate exactly the hours of the previous licence, the licensable activities of the previous licence, but what we thought we'd do in the process was seek to update the conditions, because the conditions that were on the old licence stem back to the old public entertainment licence. And as you know, they haven't existed since 2005. So they really did need updating. So just to put some flesh on the bones, I'll deal with the application in three parts. The applicant, and as Carol says, I'll explain the applicant's relationship to the tenant, the application and the steps that we are proposing to ensure the promotion of the licensing objectives, and just to deal with some of the issues raised in the representations. It won't take me very long at all. First things first, the applicant. The applicant is Wellington Pub Company. It's the largest free of tie pub company in the country. It has about 800 pubs, and it stands in the place of the old brewery that we all remember, where the tenant runs the pub, but it's the tenant's licence and the tenant pays rents to the pub company, and that's effectively where we stand. And of course, it was our tenant that went bankrupt because the tenant held the premises licence. So that's who we are. Where we are right now is in a bit of a chicken and egg situation, because we want to market the property, but we haven't got a licence. So we need to get a licence back before we can market the property. We talked to environmental health and the police about this, and what we've agreed is conditions that are effectively a framework which an operator wouldn't need to operate within. So that's the applicant, Wellington Pub Company. The application, as I've said, to replicate exactly what we had previously, to update the conditions, and we worked hard with PC Swallow, who I'm sure is well known to you, with Verity Potter from Environmental Health, to get some conditions which provide a framework within which the new operator will need to operate if that new operator wants to operate it as a pub. If the new operator wants to operate it as a restaurant, we may have to come back to change the license, but what we need is a license before we can go to market. So, as I say, at this stage we haven't got anything, but from those conditions in section 5, there's everything you'd expect to see on a modern fit-for-purpose license. CCTV, door supervisors on a Friday and Saturday night. If it's going to open as a restaurant, then obviously we'll have to come back to get rid of those. Body-worn video, again, it's pushing things to the nth and the most modern degree. Incident records, vulnerability policies, noise management plan, training, age verification, refusals log. So very different from the old public entertainment license conditions, which determined the fabric that your curtains needed to be made out of. So we have a comprehensive and robust set of conditions, far more so than previously. 3 minutes before the fire alarm. Just turning to the issues raised in the representations, we just need to put those slightly into context, because we know that we're applying for what we had before, and we've seen that there are some complaints over the years, but I think the important thing here, well, the important things are twofold. Number one, the responsible authorities have absolutely no objection to the regrant of the licence. And you know that, you know, if the police or if environmental health had any problems, they would be here to tell us about it. The second thing, and what we need to bear in mind, is that this licence wasn't lost due to any problems. It wasn't reviewed. You know, the extent of the problems, such as they weren't enough for anybody to lodge review proceedings to come back and say, well, this licence isn't fit for purpose. And I understand the concerns of the residents, because what they see is, oh my God, 1 o'clock in the morning, live music, recorded music. Yes, but that's exactly what we had previously. We're not seeking to extend the hours. So in my last 90 seconds, what are the issues raised by the representors? Number one, hours. They talk about extended hours. They're not extended, they're exactly what we had previously, and they form hours within which a new operator would need to work. Drinking across the road. Now this, you know, we can deal with. We think a lot of that was probably COVID and people using the small little area next to the bike shop as a beer garden. Well, that's not good enough. Well, that won't happen again. And so what we will do is we will offer an additional condition, which, for your legal advisors note, forbids drinking vessels being taken outside onto Bridge Street. Failed. So I'm suggesting a condition which says no drinking vessels will be taken outside onto Bridge Street. Now, of course, that's a condition. Breach of a condition is an offence, and what that does is it stops people taking their drinks out at the front door, stops the ability for them to walk over the road. Again, had anybody raised this with us, the pub company, previously, if the authorities had come to us to say that this was a problem, then we could have dealt with it very, very easily then. But we'll deal with it now, and you know, we're grateful to those who've written in to say that this was a problem. It may have been a problem in COVID, but you know, we learn from COVID, don't we? We don't want things out front. There's a beer garden at the back. There's no reason why people can't take their drinks out the back. We can't stop people smoking, but you know, we can stop them taking drinks outside. Parking, well, that's not an issue we're really here today. You know, there's never been parking here. There's no change in position there. Noise. Now, this looks to me like a 14th, 15th century building originally. It's a very, very old building, and previously it has had musical entertainment. Now,
sorry, Mr. Tate, can I ask you to bring your microphone nearer to you? Thank you. We're not picking up the recording.
Sorry, I started to relax and lean back. What we've said to environmental health is we'd like to have the same abilities that we had before, but that needs to be properly managed. So, and that's managed by having a proper noise management plan, by having, excuse me, and that noise management plan will need to be produced to environmental health. It will need to deal with the type of music that is to be operated, and then how that noise escape is going to be mitigated. And looking at it, it's not, the fabric isn't there for loud music inside. If anybody wanted to do loud music, they would have to do significant sound attenuation. But what we'd like to be able to do is have that ability to do that, because of course that was the ability that it previously had. But we work with environmental health to produce it. And we're talking about noise monitoring outside if entertainment is going to be done very easily by way of decibel meter, with levels agreed by environmental health. Environmental health, of course, the experts in noise nuisance, what constitutes a public nuisance and what doesn't. Now, I've gone on too long. I promised to have finished by the end of the fire alarm. I failed to do that. I apologise to that. I know I get a second go at this once those with concerns have dealt with it. But the application is really, please can we have our licence back? Thank you very much.
Thank you. Have you any questions?
Thank you, Chair. Just some clarification, really, I think. The picture you painted is that it was a wet-led pub. The leaseholder couldn't make it pay as that, therefore surrendered the lease or went bust or whatever. And clearly it's in your interest as a pubco to get somebody back in there ASAP who can make a run of it. In your judgment these days, are such wet-led pubs viable in locations like that?
I act not only for Wellington, I act for Stonegate, which is the biggest pub company in the country, and a number of other operators. And then the answer to your question is quality will always succeed. Where the pubs that don't succeed are the people who don't provide a quality operation. The other end of that scale is your Wetherspoons, but you know they are reliant on huge economies of scale, which of course an individual operator in a Wellington pub won't necessarily benefit from as much. So quality operation, yes. Restaurant operation, yes. Wet led, bang bang, boom boom pub, probably not. No. And what we're looking for is an operator with a quality product or with a quality offer. It's in nobody's interest for us to cause anybody any problems whatsoever. What we don't want is another closed pub, and we will do everything we can to make it work.
Okay, thank you.
Thank you, Chair. Yes, I have a question with regards to the vessels being taken outside. You're planning on doing off sales as well as on-premise sales. How will you manage that the off sales are not taken across the road?
Well, I mean, what we're suggesting is drinking vessels not taken outside. So if this is a restaurant, for example, ultimately, and somebody drinks half a bottle of wine but wants to take the remainder home with them, that's the idea of off sales. As you'll know, virtually every pub in the country has an on-off license because historically they always did under the 64 Act and previously. We're not suggesting that this will be a bottle shop or anything like that. What we're trying to deal with is the mischief of people taking their pint glasses or wine glasses or whatever it is that they bought inside and going to sit out over the road. As far as what people do with their off sales, well, of course, you know, that's a matter of personal responsibility. We can't, you know, dictate what they do. We can just dictate how they behave on and in the immediate vicinity of our premises.
Thank you.
Thank you. I think that's covered everything that I was going to ask. Responsible authorities, we have got nobody here for that.
Chairman, just while there's discussion on the drinking vessels for members' consideration, it could be worded slightly that some premises licence have the word sealed. Drinking vessels can be removed from the premises because that's where the expectation is that that person is taking it home.
What I would suggest is that the condition was only drinks in sealed containers. Or open vessels may not be removed, or only sealed vessels may be removed. It's the same thing either way.
Yes. Feel comfortable with that? Yes. Yeah.
Thank you. I have a query with regards to the opening hours. So standard opening hours close at 11 o'clock as opposed to midnight. Why do you feel that the extra hour for both live music and sales is necessary?
the intention is, of course, you build in a drinking wall, what we used to call drinking up time, and the intention was to be able to have, as it was in 2005 when this was converted, your music whilst in the period of drinking up time, which isn't an unusual situation. You close the bar, but you keep the music on, you wind the music down whilst it's happening. I mean, we're presupposing there's going to be music.
Okay. We've had somebody here for the responsible authorities. Right, so now can we go on to the other persons? Can I call Jeremy Culverhouse? Yeah.
Thank you for being here.
Can you pull the microphone a little bit closer to it, please?
Is that right?
Now, can you bring it a bit further? We seem to be a bit quiet today for some reason.
I can let rip if you want me to. What I was going to say has actually been based on before I heard what the applicant's solicitor or advisor has said. So please forgive me if I say something that sounds provocatively antagonistic. My response to the application of this license was initially based on preventing the nuisance of the noise made by customers popping out for a ciggy, leaving the premises either to go home or continue their drinking, and conversations outdoors at unsociably late hours. A matter, you may say, that could easily be rectified by shortening the pub's opening hours and establishing an alcohol control zone. Also, there's the matter of the volume of the music to be played. There's no mention in the application of how loud the music will be, other than that the level will be acceptable. But acceptable to whom, I wonder? Health and safety websites weren't able to help me on decibelage for pubs or people working in areas like that, so it was just far too complicated for me to concentrate, to take that in. But the age and layout of the building, it is old, but it's not listed. It make it difficult and probably uneconomic to soundproof it to modern standards, which throws up doubts as its feasibility as a decent music venue. Having read some of these these observations, other residents and businesses haven't had good experiences, going by the difficulties faced by those seeking consideration to their concerns. You may think that this will change for the better under fresh management, and that a licensee experienced in pub life of this type will prevent similar issues. But when the licensing officer writes, the application received is very similar to the premises license previously granted, the correspondent's reaction was to ask, so how are things to end differently this time? Well, 3 of the licensing objectives include the word prevention, and I would ask members of the subcommittee to judge whether there is any strong, effective evidence of this application, that this application relies more on prevention than on reaction. Thank you.
Thank you. Any questions? Yeah.
Thank you, Chair. Given, as you said, we've heard a representation from the applicant as to how the premises might be operated in the future, do you have any evidence to present to us of incidents in the past that have caused nuisance?
Only
we
those
might wish actively now to prevent.
Sorry.
Do you have any evidence of incidents where nuisance has been caused that you would wish us to take into account in terms of prevention of nuisance in the future?
None of which I was present, but if I were to believe, and there's nothing to suggest I shouldn't believe some of it, the representations of other persons and their observations is the closest I get to that.
Okay, fair enough. Thank you.
Can I just
Yes, please.
just a legal point? The representations made by the other applicants they're here today to amplify what they have already said. We cannot take the evidence that they've presented is here for us to see already, so we can't take into consideration anything new that they're going to be adding in this hearing. Just for your purposes. Thank you.
Thank you. Carol, can we just clarify the alcohol control zone? Does this premises fall within it?
Yes, Chair. So the premises is covered by the alcohol control zone, as I mentioned in my introduction. It
Yeah.
doesn't apply to the premises,
No,
so
but
licensed premises
outside.
are exempt, but the area outside would be covered by the control zone, yes.
Yeah, so that would be a subtle difference to what was in.
So it effectively gives the police and other authorised officers additional powers to deal with drinking in streets and antisocial behaviour. There's because it's under a public space protection order, that gives additional powers.
Thank you. Colin Webster, please. Yeah.
My name's Jeremy Culverhouse. So did I just hear that you said that we couldn't give an example of aggression or fighting on the streets?
What I said was that the evidence before the panel has already been presented in written form. You're here to amplify those concerns. Anything new won't be considered.
But to give you a specific example, is that allowable in the committee now?
You may give it an example. Whether that's taken into consideration is, it's their sole purposes of amplifying your representations.
Okay.
Thank you.
So one of the things that I kind of wanted to ask was the kind of duty of care that the Wellington Pub Group have to the tenant, and therefore the quality of tenant being important, because you are a propco rather than an opco, aren't you? And therefore it really is the quality of the tenant who we should be assessing. So I can give you an example that on one night when a bouncer was knocked out, there were 20 young men fighting on Magdalen Road. It spilled onto St John Street. In front of our house, there are young families on our road with young children. It's a very frightening experience, and it generally happens most weekends. So again, one of the questions I had is, to what level over the last 12 to 24 months do you have on-site visits to your tenants to actually see whether they're putting in place the measures that you articulated earlier today?
Yeah, please.
I'm Andrew Lee. I'm property manager for a company called Criterion Asset Management. We manage the portfolio of pubs on behalf of Wellington, and I'm the property manager for the Rising Sun. I would certainly have been visiting every 2 or 3 months. Wellington have a very strict criteria in terms of the way they choose their tenants. They're much more picky than a lot of the other pub tenants in terms of their financial stability, their experience. The previous the tenant that went bankrupt, he was an experienced operator and been running that pub for somewhere around 10 years. But I think obviously we had COVID, and that crippled him a bit financially.
And he and his wife were a particularly articulate and extremely nice couple, which leads me to believe if he couldn't control it,
obviously some of these problems I suspect were COVID related because of the way that people were being outside and all this kind of thing. Also towards the end, he did start running another pub elsewhere, and he put a manager in there, and I think some of those issues were a result of that he wasn't hands-on. So, obviously when they put a manager in, we lose a little bit of control, but we do keep very much an eye, and certainly if we get reports from the licensed authority that there's issues, we come down hard and we deal with it. We are a responsible pub company, and it's very important that we don't antagonise our neighbours. In terms of things like noise, obviously there's statutory rules on causing nuisance. We're well aware that over the last few years there's more residences very much nearby, so we're not, to be honest, really anticipating that there will be a significant music use going forward, because we don't think it's sustainable because of that. And that's a common problem around, to be fair, in terms of pubs in areas where there's been increased residential by conversion of offices, etc.
Could I just like to come and spend a weekend with us and actually hear it
Could I
first
just ask
hand what we go through?
where Mr. Culverhouse's representation is? I can't find it in my.
Mrs. Culverhouse.
Chair, it's on page 52.
Oh, right, that's
Sarah
the Sarah
Culverhouse.
Culverhouse. Right,
Yeah, Jeremy.
He writes better than me.
right.
I think that's all I've got from my perspective.
Thank you. Have you got any more? No, thank you. And the last person to speak is Greg, right, and Marion Donnell. Sorry if I got your name wrong.
Just looking for my sheet, Gregor Conacher.
New phone, I put it on mute.
Yeah.
My wife and I, don't think that we can stop the pub from coming in, and not that we really want to. We would just like the pub to act like the other
Sorry,
pubs.
can you speak up a little bit?
Sorry?
Yeah, that's better.
We would just like the new owners to operate the pub in a way that is like the other pubs in the area, such as the Bishop on the Bridge, the Willow Tree, what was previously, I think it was called Five Bridge Pub before a Kyoto restaurant came in. They all had reasonable operating hours that ended at 11. Typically, my understanding that you can continue drinking for another half an hour after the closing hour. So that means by 11:30 that the people would still be potentially leaving. As far as I know, none of those facilities or pubs have the number of complaints of noise disturbances being called in as what this pub at the end of our street is. A lot of our complaints that we raised after having listened to what had been previously said cannot be directly controlled by the owners of the pub or the operators of the pub, such as the lack of parking and the lack of the city patrolling it and, ticketing the people who park illegally and come out of the pub and get into their car drunk and drive away. Our parking in our private car parks, which, we have doctors who work various hours and various shifts. We've got people who work in the charity operations overnights and things. So we've got people coming in and out all the time, and people coming in to park in our parking spots just to go over to the pub is, very inconvenient and, causes a lot of problems to the residents who have parking spots there. The extended hours, like I say, we don't see that the pub is going to be able to gather enough extra income from one extra hour. But if you're being woken up at 11:30, it's one thing. If you're being woken up at 12:30, it's another. There are young kids on the street as well. So again, you don't like to have children, woken up in the middle of the night and have their activities the next day impacted. The illegal activity, some of which we suspect, I can't say that I can prove, went on in the pub, but based on the number of incidents that have happened over the last few years with the prior operation of the pub, unless they greatly change the clientele that's going to be coming to their pub, I would suspect that those people are going to immediately come back to the pub and to the area where they can congregate. That little park outside the bicycle shop is a perfect place for people to gather and sit and drink, because previously they allowed you to take out plastic cups of beer and wine and take them across the street and drink there, and they just sit and drink and throw their garbage around on the ground. And you could find in the morning, cigarette butts, marijuana butts, needles sometimes, and stuff like that. Again, part of this is more of a police issue and patrolling and keeping an eye on the area than it is necessarily the pub's responsibility for those people's activities. Because again, once you say you go across the street, they're not in the pub's control, but it has a great impact on the neighborhood. Part of the activity too is that these people coming out of the pub urinate and defecate around the park and in our parking lot and up and down the street. They vomit and leave the vomit on the street. Again, that's not necessarily isolated to their pub. Other pubs probably have the same issue. But again, it is one that is very prevalent, again, because the congregation of that park and the benches there and the people spending a lot of time drinking outside in that area. The noise, I don't understand how people inside the pub can carry on a conversation or have any hearing left when we have to close the windows in order to be able to hear our TV, and we're 50 meters, 100 meters down the street, and yet we can't even carry on a conversation in our own house. So it must be very loud in the facility itself. And closing the windows on our street, the side facing us, does help. And we used to have the 5 bridge, they have a garden in back, which is again about 50 meters from us. And they occasionally had music and stuff playing in the garden that we could hear, but it never became so loud that we, had to close our doors or windows when they had their music and stuff going on and everything. So I do know that pubs can control the music and the level of the music, so that they can be good neighbors. So I think the noise and the extended hours are the two that are things that we highlighted that can be under the direct control of the pub. The other ones are more of a thing of knowing the nature of what happens when the people leave and whether or not we can get support from the council and the police to better patrol the area. And I've been informed that we as citizens in the area need to make calls more often and more frequently to establish a track record of how often it does happen, so that action can be taken and issues can be raised higher into the government bureaucracy, and maybe something can be done in the future. Thank you.
Okay. No.
Thank you, Chair. Just to clarify with the licensing officer, really, it does say, and I think it was stated by the applicant's representative earlier, the hours are as they were on the previous license, with the exception of regulated entertainment over Christmas and New Year. Is that correct?
Yes, that's correct.
Yeah.
Right, I think that's covered most things. Uh, Would you like to clarify any of what we've heard?
I'd just like to take the opportunity just to address you very, very briefly on the law and the policy, if that's in order, sir. So, it's a new license application, and the Home Office guidance is very, very clear on how decisions are to be made. And it's, for your legal advisor's note, it's paragraph 9.43 or 43 of the Home Office guidance that says the authority's determination should be evidence-based, justified as being appropriate for the proportion, for the promotion of the licensing objectives, and proportionate as to what it is intended to achieve. And that, of course, comes from the case law, doesn't it? The case law says, we determine licensing applications on the basis of real evidence. We don't do it on supposition or what happened, 3 miles down the road or wherever it might be. So what we need here is an evidence-based decision which is proportionate as to what it is intended to achieve. And what it is intended to achieve is a replica of the previous license. So what is the evidence both for and against the replica or replicating the previous license? Well, number one, in favour. The application is made because of an administrative error. If the form had been filled in and £23 had been paid, we wouldn't be here. It's very important because this is just starting to feel a little bit like a review. This license wasn't lost due to any complaints, any history of problems. It's an admin thing. And so we need to consider that when when you come to the end in your deliberations as to whether or not you're going to replicate it. Evidence in favour. The responsible authorities do not object. Now that's powerful. Again, the Section 182 guidance is very clear. Paragraph 9.12, the responsible authorities are to be regarded as experts in their particular field. So the evidence is that the experts in noise and nuisance do not object. They are happy with the conditions. Funnily enough, it's because they asked for them. But those conditions will give Greg what he wanted. What Greg said, or Mr. Connick said, I beg his pardon, is that he knows pubs can operate without causing a nuisance if they're well managed. And those conditions will ensure that noise nuisance is not caused and that any noise within the premises is properly managed. Similarly, evidence in favour. The police, we've heard, there was some fighting, some unpleasantness, some antisocial behaviour. The police are your primary source of advice on issues of crime and disorder. Home Office Guidance, paragraph 2.1. And the police don't object to this. You know PC Swallow much better than I do. Having spoken to him on a number of occasions, I'm sure that if he had any problems with this application, he'd be here to tell us about it. But he doesn't. The evidence, and you heard from Mr. Lee, a major pub company who has worked with the authorities to relicense the premises bigger with much more robust conditions than previously existed. A pub company who wants a quality operator. Nobody wants a closed pub, and that's what all we're seeking to do here. So on the other side, well, what have we got? Well, certainly never enough to establish a review of the premises license. And the evidence that we've heard is pubs can be good neighbours if they're run properly. You've heard Mr. Lee say, we will be there. The previous operator, he took his eye off the ball, he went off to operate another pub. We won't let that happen here. What we want here is a pub that's a benefit to its community rather than a burden upon it. So there is the evidence. Would a refusal be a proportionate response in these circumstances? Well, I don't think it could be. Would a reduction in hours or removal of licensable activities be proportionate? Well, in my respectful submission, no. The evidence is that whatever the issues were, it wasn't enough for anybody to consider review, certainly not the responsible authorities to come here and say, no, that's too long in that particular location. What the responsible authorities are saying is, with these conditions, that's fine. We are satisfied that this will not adversely impact the licensing objectives. And of course, So I will say, yeah, the only proportionate response is a grant in the terms sought, because there's no evidence to justify any dereliction from that or any movement from it. So in all of the circumstances, I'll start where I finished. Please can we have the licence back? And of course, if there are any problems, there is still there's still the option of review proceedings if the concerns, because they're nothing more than that, of the neighbours bear fruit, or if they manifest themselves as fact. So please can we have the licence back? Thank you.
Thank you. Any comments? Aaron?
Thank you, Chair. Just some thoughts for the applicant and for the committee to consider. One thing that struck me earlier is the obvious concerns of the local residents about the new management. Is there scope potentially for when the new tenant, if a licence is granted, comes in, to set up a residents meeting or reach out to the residents to be able to meet them directly and discuss the way forward of the pub? Put you on the spot there a little bit, sorry.
No, that's always a possibility. I mean, any responsible operator would want to work with the neighbours, and we encourage that and assist them where we can. So I would think that any responsible operator that goes in there would wish to have conversation with the neighbours and work with them to make sure that any of these issues are minimised, so that they don't come across, that there's a review and they have problems with licensing going forward. It's a very common thing they do. And hopefully some of the locals would actually come in, enjoy the pub and use it.
I think it's worth also mentioning, Chair, I'm not aware of the boundaries of the police patrols. You're probably aware, and I was speaking to some of the residents before the meeting, that the two teams of the police officers that are now patrolling Winchester city centre, where that stops effectively for the city centre, they probably have a route. I'm just not sure it stretches as far as past the Broadway. I don't think it would go up towards the Rising Sun, but that's something that obviously we can pass back to our colleagues in the police in terms of the scope of where they patrol, if that's something that we think would be useful. I mean, again, the police's patrols will be evidence-based, so unless there's, a good reason for them to extend that, if that would be the case, but I'm certainly happy to contact them and speak to them about the police patrols in that area.
Yes, I think that'd be a good idea, particularly as it's within the alcohol control zone as well.
Yes.
That we've got a bit of backup on that for the residents, but
Yes.
it's much important.
Yeah, and I think they're cast as separate things, I think, from the police. I think the alcohol control zone primarily, and that's not completely, but I think primarily was for daytime issues.
Yeah.
It can lead into the night. And then the police patrollings are particularly for the nighttime economy. That's a completely separate project for the police that they started last year, which has been positively received in Winchester. I think it's important to note also that there's the pub watch scheme in Winchester. So if potentially this is a wet-led pub type premises, then that's something the committee may consider, or for the pub code to consider, is that interaction and being an active member of pub watch obviously have its benefits, because then you know who are on the banned list, who you don't want in your premises, because
I would certainly encourage that. Yes, obviously.
Often being on the boundary or just outside of the town centre, when they're banned from the pub watch pubs, they then go a bit further out until they can't get in any more pubs effectively. So it might be very useful that actually you become an active member of pub watch as well, and you may consider that that's a condition of licence. The only other thing that to mention is there's reference to entertainment, and I note that there's no suggestion by Environmental Protection about limiting the number of days, but I just wondered whether for the applicants, and I appreciate obviously the times that you've put forward are the same as you previously held, but is there any likelihood to have a live band at up until midnight on a Tuesday night, for example? Would it make a big difference if the work committee were to consider conditions that would limit the number of events or particular days of the week?
I think we're in danger now of overstepping the mark. Number one, there's case law on whether or not a pub watch condition is enforceable, as I'm sure you know. So I'm a bit worried about that. Number two, I think we've got to deal with the evidence. And the evidence is that environmental health have no objection to this licence being granted in the terms sought, subject to the conditions that are acceptable for environmental health. It will be for the operator ultimately to work within the framework of those conditions, and it will be for the operator to say to environmental health, well, we're going to do this on this particular night, and these are the steps that we've got in place to ensure that. And I'm very keen that we don't start limiting things by guessing what might happen in the future when the experts are already happy with the status quo as it is.
I think it's just being mindful that if we can involve the residents, I think that's a big key for not in the planning, I mean, in terms of telling them, because we all know that when the residents are much more aware of what's happening, that can make a big difference.
I think the key here is that we will do everything we possibly can to ensure that whoever is going to take that pub engages with the residents and shares the plans for the pub, as far as licensable activities are concerned, with the local residents. As I said, we want this to be a benefit to the community, not a burden upon it.
Yes, I think it's important that they work with the local residents on that. Just one question with regard to the noise. If I remember rightly, we've had instances of older buildings having entertainment in them. We've put some sort of noise control feature in for the residents to make sure that the sound coming out of the building doesn't reach a certain level.
I think you're talking about a noise limiting device.
Right.
Yes, it's possible to have a noise limiting device.
Yeah.
So yes, through which any amplified sound is played through a limiter, which then is set in conjunction with environmental health, who stands outside and say that's too loud, that's fine, set it at that, and then it's locked and can't do. But of course, that could form part of a noise management plan, but we're not quite there yet. But again, it's incumbent upon the operator, and Wellington will, this will be Wellington's license for a period of time, to ensure that that's exactly what's done. Now, again, we're guessing what's happening, and when I discussed things with Verity, we didn't know what any entertainment was going to be, hence the way that it's looked at. Now, if somebody wants to turn this into a live music venue, you're absolutely right. The fabric isn't right. Soundproofing would probably be nigh on impossible. I suspect that moving forward, music will be a very, very limited part, if at all, of any offer.
Yeah, I think it's important to take the residents in
along
with you. So that's
absolutely
what we're trying to do as well. Yeah,
I think I would just observe that yes, a noise management plan is part of one of the conditions, is it not? That will come along if you go down that path, and then clearly environmental health will take a view on what's in there.
Yes, and I think the noise management plan needs to relate to the premises and the entertainment that's being provided. And to be fair, at this stage where we're not aware of who the tenant will be, what the future plans will be, that makes it difficult, and that's why such a condition has been agreed at this stage.
Yeah.
Things like noise limiters, for example, are an added cost, and if they are not appropriate, should not be considered until a later stage. The legislation is permissive, so it gives the opportunity to allow things to happen, and then there is controls and ways to deal with that if the conditions aren't complied with or there are issues in the future. And that's how our legislation is led. So it might be that if noise, hopefully not, but in a wider context, if noise nuisance becomes a problem, that's what the review process is for. And that's where the committee can then look at stricter conditions to limit or restrict timings on things like entertainment.
Yeah, thank you. Good. I think that brings us to the time when we have go into exempt to make a decision. So are we staying here or are we going?
Members will remain in the room, and Carol and the Wickham room's booked.
Yeah. Yeah, that's fine. Yeah. So if everybody likes to retire down to the Wickham room, if you'd like to go down to the Wickham room, what I'm really trying to do is to reassure the rest. Thank you. In reaching its decision, the subcommittee has carefully considered the application, representations made by other persons, and acknowledged the agreed conditions with the Environmental Protection and Hampshire Constabulary and the applicant's representations today. It has taken into account the Council's statement of licensing policy, the public sector equality duty, the Home Office guidance issued under Section 182 of the Licensing Act 2003, the duties under the Crime and Disorder Act 1998, and the rights set out in the Human Rights Act of 1998. The subcommittee has concluded that the application should be granted with the agreed conditions set out on Section 5 of the report, with the following additional condition. 1. No drinking open vessels to be taken out through the front door. And for the following reasons. 1. The panel has noted that the responsible authorities, Environmental Protection, Hampshire Constabulary, were no longer objecting to the grant of the application. Taking into account all the circumstances, the conditions offered and agreed by the applicant and the responsible authorities, which were reasonable and proportionate, sufficiently promoting licensing objectives of preventing crime and disorder, prevention of public nuisance, and the protection of children from harm and public safety. The panel was sympathetic to the objections raised by the 8 residents who made written and oral representations that were carefully considered today. These related to, in the main, the prevention of public nuisance and the prevention of crime and disorder. The panel also considered the applicant's solicitor's response to these objections and conditions offered to allay any fears that the residents may have by offering robust conditions. Oh, yeah, something wrong here. I'm just going to get rid of that. Sorry, I got finger trouble. The panel considered the written representations on the grounds of prevention of crime and disorder, public safety, and the prevention of public nuisance. The panel was aware that it could not make assumptions as to any potential impact the requested application might have in relation to the licensing objectives, but must reach a decision based on the evidence before it. There was no evidence which could be presented to show that granting the application would undermine the licensing objectives. The panel noticed that the Licence Act of 2003 provides an alternative mechanism for dealing with the issues where the premises on the balance of probability, the panel is satisfied that granting the application in the form of the amended application with the additional agreed conditions would not undermine the licensing objections of the prevention of public nuisance, prevention of crime and disorder, protection of harm and public safety, and the protection of children. The panel has also taken into account the relevant provisions of the Human Rights Act 1998, namely Article 6, the right to a fair hearing, Article 8, respect for private and family life, Article 1, First Protocol, peaceful enjoyment of possessions. The panel considers that in all the circumstances, the conditions offered by the applicant and agreed with the environmental protection were reasonable and proportionate, sufficiently promoting the licensing objections of the prevention of public nuisance and the prevention of crime and disorder, public safety and the protection of children from harm, that the objectives would not undermine by following variation of the licensing. The parties will be formally notified of the decision in writing shortly. This notification will include details of the right to appeal against this decision to